Hello, everyone, and welcome to the fourth webinar in our disaster webinar series. I feel like we're getting to know each other through this series. Today, we're going to hear about renters after disaster with Tom DiFiore. Tom is team leader for the Housing and Consumer Unit of Bay Area Legal Services. His team focuses on housing, consumer, employment, and public benefits law for Hillsborough County residents. I'm Kathy Grunwald, the Disaster Coordinator Attorney at Legal Services in North Florida, and I'm here today with Carlin Selders, our Disaster Program Assistant. I'm going to remind you again of these 4 housekeeping details. If you have questions, type them in the Q&A at the bottom of the page or the bottom of your screen, and we'll answer them as they come when we can, and time permitting also at the end of the webinar. The webinar is being recorded, and I'll send you the link to the recording along with the PowerPoint and the CLE information after the webinar. The program has been approved by the Florida Bar for CLE credit. Also, after the webinar, you'll get a short survey, and I'd appreciate you taking the probably 2-3 minutes to answer the survey. And I want to thank you for coming today and encourage you to come back for, after today, our remaining 4 webinars. And with that, I'm going to turn this over to Tom DiFiore.
Thanks, Kathy. As Kathy said, I'm the head of the housing unit at Bay Area Legal Services in Tampa. We're going to be speaking today about the impacted residential and mobile home tenant as a result of a disaster. And candles in the wind is an appropriate name for that because it's a very vulnerable position to be in if you're a low-income person after a disaster. So we'll start this. Let's see how this is working. There we go. So first off, residential landlord-tenant law in Florida, and I know we may have some people from outside of Florida, basically is governed by Chapter 83. That covers residential landlord-tenant relationships, and there is no actual requirement for a written lease agreement, but any written lease agreement cannot go beyond or give less protection than Chapter 83, which is the landlord-tenant law. An example would be if you have there's a 3-day notice requirement for non-payment of rent, you can't give a 2-day notice, or you can't extinguish other rights like that. And mobile home parks, especially, have residence rules and regulations. They can also appear for a regular landlord-tenant case, but we'll get into that a little later. So usually with a disaster, the big issue is going to be repairs, right? So there's a storm hits, there's roof damage, there's water damage, there's could be total damage. So what does a tenant do in this situation? So the landlord-tenant law addresses repair to premises under 83.51. Essentially, if there is a non-compliance with a building, housing, or health code, or when there's no building, housing, or health code, there's the requirement to maintain with general maintenance, as you're seeing here. Arguably, this applies before and after the storm if the tenant remains in the property. And if you're in a single home or duplex, you can modify that in writing. And if you're in if you own a mobile home, the landlord obviously is not required to maintain that home. We'll get into that a little later as well. So what happens when you have repair problems before the storm? In a general situation, not my favorite part of the landlord-tenant law, but the tenant is required to give a written notice at least 7 days before the rent is due, basically saying, hey, here are the problems that I'm having. You have 7 days to make reasonable efforts at repairs. If you don't make those reasonable efforts, then I'm going to withhold the rent. So you can't fix the problem and take it off the rent. No repair and deduct. Some states have repair and deduct. Florida does not. The problem with the this section of the landlord-tenant law that we really don't like is that by withholding your rent, what obviously happens next is if the landlord doesn't want to make the repairs, then they say, well, you're not paying your rent. They deliver you a notice for non-payment of rent called a 3-day notice, and they file an eviction. So you're almost forced in a lot of ways, if you want to get repairs done, to make a landlord actually go to the point of actually filing an eviction, which is not the greatest procedure, but it is the one we have. And then again, if no reasonable efforts are made, then you can withhold the rent. There's two types of notices. One is to withhold the rent, and the other is to vacate, a 7-day notice that says, if you don't make the repairs, then I'm going to terminate the lease and leave. So that's what we typically have. Here's an example. This is a form we often use with clients. This is to inform you of the following defects of the property. This Florida law requires these conditions be corrected. And if you don't make reasonable efforts, we will withhold rent or sue for injunctive relief. So that's a possibility, not taken about too often, but you could ask a judge for an injunction to order the repairs done. So this is the form to be sent for that purpose. So what is the effect of this 7-day notice? Again, I think I've probably covered this already, but if the landlord makes reasonable efforts, then you're supposed to pay that rent. So if you're saying my refrigerator is broken and the landlord on day 6 says, here's the receipt, I ordered the refrigerator, that's a reasonable effort, arguably, and you should pay your rent. If not, and the repairs are not done, then generally the tenant deposits that rent into the court registry if an eviction's filed, and then files a motion to determine rent, asking the court to say, look, I withheld rent, the repairs weren't made. I want a hearing for you to tell me, Mr. Judge, what this property is worth with the plumbing not working, electricity not working, etc. And then the judge should hear testimony and basically say, well, I find that the property is worth, whatever percentage, and lower the value of that. And then they should dismiss the eviction if it's properly done. If you're terminating the tenancy and the landlord makes reasonable efforts at repairs, then basically, you have an obligation to stay in the property. If you don't, you can be held liable. If not, then you can leave the property without any liabilities. So this is all standard 7-day notice withholding, not taking into account, a disaster or a storm. What happens after the storm? Okay, so there's going to be an interplay between the 7-day notices that we're talking about and this particular provision of the landlord-tenant law that doesn't really come into play too often in a lot of cases. It will come into play, like if there's a fire in the house and it's not caused by the tenant, this can come into play. But with a hurricane or a large storm, this is going to sort of come more front and center. So we're going to spend quite a bit of time on this. So we're going to go over it pretty thoroughly and how it might play if you're representing somebody after a disaster that has some damage to their property. So I think we're probably going to go over this section piece by piece, but essentially the key elements are, is the premises substantially impaired? Was it a wrongful or negligent act of the tenant? Assuming it wasn't and it's substantially impaired, then you get into next. You can terminate the agreement and vacate altogether, or if it's only a portion of the premises that's rendered unusable by the casualty, then you can basically argue that the rent should be reduced by the fair market value of that portion of the property. So there's a complete impairment, basically, and a partial impairment where this can come into play. So we'll go through that next. So what is, in fact, a casualty that was mentioned in the statute? So it's defined as an inevitable accident, an event not to be foreseen or guarded against. So for our purposes, if there's a flood from hurricane rain, wind damage, fallen trees, burst pipes, etc., that is clearly casualty damage. Sometimes we try to be creative with the casualty damage provision in other cases, like a failure of a landlord to provide air conditioning, or other ways that you could try and argue that. But the classic way of a casualty is clearly going to apply, in damage from a storm. So this slide and the next slide are probably going to be the heart of our presentation. What do you do if you're going to claim full casualty versus partial casualty? So we went over this a little bit, but again, here's that substantial impairment of enjoyment. If you have that without any negligence on the part of the tenant, then the tenant can terminate the agreement and vacate the premises. So if there's a fire on the property and it's clearly the tenant's fault, arguably this doesn't apply. But there's no tenant I know that has created a hurricane and caused wind to fall, a tree to fall on the house or so forth. So that's usually not going to be an issue here. But the question is, what is substantial impairment? So what does that mean? What are the legal grounds for that? And like a theme running on 83.63, this section is, there's not a lot of case law out there. There's not a lot of discussion of what that means. So there's no clear definition in the statute itself about what substantial impairment. Generally, we'd say if more than 50% of the property is damaged or destroyed. I think you can argue if one or two rooms are flooded and can't be used, that also could be. So it's pretty broad about what substantial impairment means. How do you claim it? So we talked about a 7-day notice being delivered to a landlord. This section doesn't really have a specific direction about how it's supposed to be done. So what we are basically advising or recommending is you provide written notice to the landlord, basically saying, hey, here's the damage. We've lost access to the property. The roof is open, water's coming in, the cause. And if it's bad enough, we're just out of here. We're vacating immediately. We don't have any further liability under this agreement. Put that all together in a letter, make sure it's delivered to the landlord, and keep that for any future issues. When do you do it? As soon as you know the tenant is vacated and won't return to the property. Oops, I guess I want to go back here a little bit. Sorry about that. So practice pointers. So this is the full casualty again. So after you send this notice, and again, consult with your client about what they want to do or not do. They may just say, I just want out of here. I don't want anything to do with this anymore. You can send the notice. Now the landlord may say, well, you can't come back on the property. We had that with the hurricane that came through here. A lot of people saying, well, the landlord's not letting me back on the property, Hurricane Irma. And they may say it's not safe, or we're not going to let you back in there. So if possible, before you send this notice, basically calling an end to the tenancy, have a claim adjuster, if you have renter's insurance, which not many of our clients do, some of them do, or the FEMA representative, if there's no renter insurance, visit the property. So it's probably best to wait until there's actually a person who comes out there and does an adjuster that does an investigation. If that's not possible, then basically advise the tenant, look, get anything you can salvage out of there, take pictures of damaged items, since you may not be able to get back in there, and then at that point you can move. The last bullet point here, if we're not really sure whether it's substantially impaired, maybe it's not that severe a damage, then probably the best way to go, and this is the interplay, is to go back to a notice to terminate, the 7-day notice. The advantage of a 7-day notice, I guess one of the few advantages over claiming full casualty or casualty provision, is you only have to have one violation of codes without remedy to terminate a lease. Whereas under this provision, it has to be substantial non-compliance or substantial impairment. So there needs to be more than probably just one particular problem. So you got to sort of see where your facts are, whether you're going to give a 7-day notice or whether you're going to go under the casualty route. So we talked about full casualty. Basically, we're moving out there's no way I can stay here. This is not habitable. Let's make sure I don't have any liability to the landlord or anybody else when I move out. What about partial casualty? So 83.63 says if the tenant can vacate the part of the premises rendered unusable by the casualty. And in that case, your liability is reduced by the fair market value of the part of the premises damaged or destroyed. So there's a lot of words there, a lot going on, but essentially, as in the definition of substantial impairment, there's no real clear definition of part of the premises rendered unusable. We're presuming that would be, you have a 4-bedroom house, 1 bedroom and 1 bathroom are impaired. I guess you can do the math on that and say that that's a, partial impairment, but the tenant doesn't really want to move. They have nowhere else to go. They want to live there while repairs are being done. How do you claim that? Again, written notice to the landlord. There's no guidance in Chapter 83 or anywhere else about what that notice says, but we would certainly recommend something in writing because that's the way the landlord-tenant law works. Everything needs to be in writing. So a written notice, I guess preferably by certified mail or hand delivered, or however you can assure that, maybe email, saying, here's the part of the premises that's rendered unusable. We've got 1 bedroom that's out. It's a 4-bedroom house. Here's the damage. Here's some pictures of it. We don't have the ability to move out right now. We don't have the funds or anywhere to go. So we want to, we're not going to pay full rent. So we're only going to pay, instead of $1,000 a month, we're going to pay you $700 a month. And that can start a negotiation process with the landlord about that, providing evidence of it. And again, no repair and deduct. You can't just automatically say, this is the rent. It needs to be sort of a negotiation. When do you claim that? Again, talk to your client, the tenant. What do they want? Do they want to remain there? And look at your evidence regarding the damages, not just verbal, and make a determination about what would be a good, offer to make to the landlord about reduction in rent, right? So what are some of the potential issues? So after sending this, the landlord may say, hey, that's way too much. I'm not going to give you that much of a rent reduction. The landlord could say, well, we went in and made repairs and we want more rent. I think that one's pretty unlikely, frankly, but maybe not. And then the last one, they may ignore you altogether and say, well, we're just giving you a 3-day notice for non-payment of rent. You owe us $1,000 or $2,000 for the last 2 months, and we're giving you a 3-day notice, and then we're going to file an eviction. So the thing about the written notice under the casualty provision, which is good, is you don't need to give this 7-day notice. All the requirements of that it's 7 days before, that the rent is due, all that other stuff. You can basically start a negotiation just by a separate letter from the landlord. So I think this would be the more preferable course, if there was a disaster and you needed repairs done. I think it's a back and forth with the landlord talking about, how much of this damage on the property, is there any way we can make an arrangement so that we can stay here and live? What's the plan on making repairs? That sort of thing. So if the tenant does claim partial casualty and decides to remain on the damaged premises, the landlord still has the obligation to keep the place up to code. I guess arguably you wouldn't say, well, the place is not up to code because the bathroom isn't fixed yet, if they're in the process of fixing it and they're making efforts to fix it. But if other issues come up, you can still give a 7-day notice to withhold rent, although that can get a little tricky. So I think in the context of a disaster, a hurricane, I think this 83.63 section of the Florida landlord-tenant law, I think really comes into play. May not make too much sense now, but I think when and if you're facing a situation, first thing you do and first thing I would do would be pull out the statute, maybe pull up this PowerPoint and go over it again, because this isn't the kind of thing that you see every day. was originally scheduled to do this training a while back, and I had to review it, and I was like, oh, this is interesting, because I really hadn't thought about it in a while, because when it's not something that comes up on a regular basis, but I think it's really important to understand this protection, and this 83.63 actually is not bad. I think it's much better than the 7-day notice part. So it's something to work with, and I think there's a lot of leeway on it. So in conclusion, on the casualty provision, you're going to see intensive fact issues. Every case is going to be completely different. Obviously, different houses have different damage. Different people will be in different situations. Different tenants have different, motivations and ability to move. And what they want is going to be, I think, at the forefront. What your client wants is really important, as it is in any legal services case, as we know. You think, oh, that's a great case. Well, there's this, that, and the other thing. And then you say, what do you want to do? And they say, well, I don't want to fight this. I want to move. Okay, well, all those wonderful defenses that we were thinking about may not need to be used if we can work out a move out time. So always remember, what your client wants. We talked about the statutory terms, substantial impairment, all those other things don't really have any specific definitions. So you can use that to your advantage. It's not written in stone. You can play with that in your negotiations. And I think negotiation is probably what's going to happen in most of these cases. Little to no case law. So again, that's good. In some ways that's good. Some ways it's you think that's bad. There's no case law, but it may be good because it's sort of a blank slate to use, and you're being reasonable with the landlord if they're willing to be reasonable, and using those casualty provisions as a guide. I think one of the big things you want to avoid is the filing of an eviction. And that's one of the problem with a 7-day notice to withhold is it typically triggers an eviction because you're withholding your rent. Here, I think that again should be something in your mind when you're talking to a landlord and negotiating. Let's not file an eviction on this. Let's see what we can do and come to a reasonable, resolution using the casualty provision as a guide. Because once that eviction's filed, and of course we're seeing that now with COVID, right? There are moratoriums in Florida and other states. We were arguing you can't file evictions during the moratorium. That didn't stop a lot of people from doing that. The CDC declaration that's out now, again, our position is you shouldn't file the eviction because the CDC order says eviction is any action taken to remove a tenant from the premises. Then the CDC came out with some FAQs last week that said, oh, we're not telling you can't file the eviction. We're just saying you can't, do the final step. So even if you assert your rights under the declaration, you still have an eviction filed. And as we know in Florida, once an eviction's filed, there is no present means to expunge it. If you had an eviction 15 years ago, it's going to show up there. So this is an ongoing issue. The same would be true in a disaster situation. It's going to be hard enough to probably find a place to rent if you're leaving a place that's damaged, but the last thing you want is an eviction behind you, because the next landlord's going to look at the public record and say, oh, what happened here? And then you have to explain it, as opposed to getting everything clear and clean with the landlord, either by moving out and terminating the tenancy, like as we talked about, or by coming to some arrangement on a reduction in rent while repairs are being done. That's the ideal world, remains to be seen how that happens on a case-by-case basis. And then again, last little blip here, consider using the 7-day notice to withhold or terminate as another procedure if you're not going to use that casualty provision. So that was a big part of the presentation. We're going to go into a couple of shift gears a little bit here to the mobile home situation, because as we all know, when a hurricane hits, where do the cameras go first? To the mobile home park. Why? Because that's usually where there's the most damage, right? Because the structures are not made nearly as well as homes. A lot of them are old. A 100-mile-an-hour wind will do a lot of damage in a mobile home park. What about the mobile home owner. So there's obviously two types of people we're speaking about in this situation. One, the person who owns the mobile home and is paying rent underneath for the land. That's called lot rent. So you pay a certain amount for lot rent. You have a written agreement with the mobile home park. You pay $600 a month to plop your mobile home on top of that. On top of that, you get a hookup for your electricity. And the mobile home park provides the common grounds, the amenities, and so forth. And you pay to rent that land underneath the mobile home. Okay. If you do that, that's one, and then you own the mobile home, right? So if you pay lot rent and own the mobile home, sort of skipping to the second part, then we get into not only a different set of law that applies, but different, results as a different outcomes as a result of a hurricane or casualty damage. So if the tenant, the other position is the tenant just moves into a mobile home park. What did I do here? Back to where we are. Okay. So a lot of times you'll have somebody come in and they'll say, well, I'm in a mobile home park. And the first thing question is, do you own the mobile home? A lot of times the answer is no. I just saw some sign, $800 a month. I rent the mobile home from the mobile home park. The mobile home park owns the mobile home, and I pay lot rent and rent for the mobile home are combined in one fee. If that's the case, then we're basically in a Chapter 83 position, which is that essentially it's a landlord-tenant relationship. And that's just what we talked about previous to this. The casualty damage provision, the 7-day notice, the landlord is responsible for repairs to the mobile home and the common areas. So you're basically a tenant. However, if the tenant owns the mobile home and is paying lot rent, then the landlord is not required, as we said earlier, to fix the tree that fell on top of the house or the wind that blew the roof off. Presumably the mobile homeowner will have their own insurance and will make a claim under their insurance policy to get that fixed. The landlord is not responsible. Now, of course, there's going to be a gray area. If the tree that fell hadn't been, it was not part of the common area and hadn't been maintained, and it was a dangerous thing and limbs were falling 3 weeks before the hurricane, and then the whole thing came down on my house, I mean, that might be a different situation. So if there is casualty damage, the mobile homeowner is responsible, but they're still obligated to pay the lot rent or face an eviction. That's another issue. So if your mobile home is damaged by the storm and you own it, but you're not paying your lot rent, potentially the mobile home park can file an eviction for non-payment of that lot rent. And if the mobile homeowner, like I said, doesn't have insurance and there's storm damage, they can consider applying to FEMA for assistance for possible repair or replacement. So we know that in cases where homes don't have insurance, FEMA is a potential backstop for that. So the same is true with a mobile home. So what about the damage to the lot and the rest of the mobile home park? So common areas, mobile home park owners must comply with local building codes. This is Chapter 723, not Chapter 83. It's a different law altogether. They're supposed to maintain the building and improvements in the common areas, basically keep the place up, including utility connections, and comply with building and housing codes, right? Also, the Florida Home Relocation Corporation, not typically seen to be used, but that may be available for destruction to a mobile home park by a storm. So we're citing here 723. So 723 applies when there's more than 10 mobile homes in a mobile home park and you own the mobile home. Then this would all apply regarding the common areas. Okay. What about security deposits? So we're going back to this section that we were talking about in the landlord-tenant context. 83.63 has a specific section that says if the rental agreement is terminated, then you're supposed to follow the regular procedure for return of security deposits under 83.49. And under that, the landlord has 15 days to return the deposit or send a certified claim by certified mail to the last known address to the tenant. And then the tenant typically is supposed to object within 15 days. So make sure if you're doing a situation where you're vacating for a full casualty, make sure the landlord has a forwarding address where you're staying after the storm so you can make a claim on that deposit. Or what about personal property damage? Back there. So this would be storm comes through, hole in the roof, all my furniture is done, covered in water, as well as my clothes and my kids' toys or whatever that might be. If you have renter's insurance, obviously file a claim. Most of our clients don't have renter's insurance, and even if they do, it's likely there's going to be an exception for flood damage. So renter's insurance policies are cheap, right? And there's a reason they're cheap. It's because they don't pay out very much typically, and they probably have a lot of exceptions to them. So, but that's one way to go if you have your own insurance claim. You can review the lease provisions, though likely the landlord's going to argue, well, we're not responsible for damaged items in a storm. You should have had your renter's insurance. Again, this is a little out of my bailiwick, but take a look at the landlord's insurance policy. Is it possible that you can make a claim under that policy for the damage? Another option is a straight up, negligence claim. Landlord had a duty, breached the duty, there was damage, proximate causation and damage. That would probably likely be the scenario of, well, you, Mr. Landlord, had a duty to maintain and clip the trees. You didn't do that. That's why this tree fell. It was already had 5 dead branches on it before the storm. Or you didn't have the roof properly secured like you were supposed to. Some sort of a duty on the part of the landlord that exacerbated that claim or caused damage to your personal belongings. And I believe the tenant can also make a claim with FEMA for loss of personal property within 60 days of a storm declaration. So that's probably the last bullet point is probably your best bet in terms of getting some immediate relief for personal property damage. So I haven't reviewed my FEMA materials in a while, and hopefully I won't have to, but usually that's when the storm comes through, you start pulling out all that. But I know that there's a way that you can make a claim for personal property and maybe get some claims paid quickly. Yes, sure.
Yes, this
Please interrupt me.
because this is a common question after a storm. Is there any way that a tenant of either an apartment complex or mobile home can force the landlord to make repairs? So there's a dispute about how livable it is. Is there anything they could do to force them to make the repair so that because they want to continue to live in that property?
I would argue, again, the interplay of 83.63, the casualty provision, you can, send a letter to the landlord and say, we want these repairs done. If the landlord refuses to do them, I'm not sure 83.63 gives you really a remedy in court. So again, this is where we have the interplay between this and the 7-day notice. So there's a 7-day notice to withhold rent. Arguably, you could give that. And as I mentioned, it does have a provision that if the repairs aren't made, you can seek injunctive relief. So if a judge finds, look, there's an entire bedroom and bathroom in this house that they're living in that is not being repaired, you could potentially get an injunction from a judge that orders that to be repaired. That's a bit extreme and maybe hard to get a judge to rule on that. But I think overall, when you say force, again, that's an interesting word, force, make them do it. The landlord-tenant law, which is applicable here, gives you a remedy. The force is supposed to be, I'm withholding my rent. I'm not paying you $1,000. That's supposed to be the force. That's supposed to be compelling enough to make the landlord say, oh my goodness, I'm not getting my rent. I'm going to run out and Home Depot and get this all fixed. As we all know, that doesn't happen. Typically what they'll do is say, oh yeah, you didn't pay your rent. Here's your 3-day notice. I'm evicting you, right? So that's an element of force. The withholding of the rent is supposed to be the thing that exerts pressure on the landlord to make them do the repairs. Does it work typically? Sometimes, but not often. So this is why I think 83.63 is a good opportunity to at least open the door to negotiation on that and say, hey, look, here's this provision. I think you could probably argue under 83 that, you know, it says that you can sue for any damages for a violation of 83. So if you made a demand for repairs, I think if you got creative, maybe you could file some sort of a affirmative action under Chapter 83. I haven't really thought it through, but it is a tough situation, I think, you know, when the landlord has got, you're muted, I think, Kathy.
Yeah. One of our participants also added, his attorney, I think in Jacksonville,
Yep.
or Gainesville, that you can also request a code enforcement inspection.
Of course, yeah. Sorry about that. I'm glad somebody else can jump in. Sure, you can, and I didn't put that in, I guess, because I guess we always tell people that, but if you have code enforcement comes out and cites the property, if they continue to pursue that, and different jurisdictions have different levels of enforcement of code enforcement, but they could start fining the landlord for not making the repairs. And having code enforcement come out is always a good idea, because that gives you specific evidence of the code violation if you get an actual report from code enforcement that there's a code violation. So yes, agreed, that is another element of potential force or pressure to put on the landlord, which, as we know, often calling code enforcement can result in retaliatory evictions a lot of the times as well.
Yeah. We have one more question is, do you have to be in litigation to demand a copy of the landlord's insurance policy?
I don't think I know the answer to that one. I understand that, you know, typically that would be something they could say, well, you're not getting my insurance policy unless you did it in discovery, obviously in litigation, or request for production. You know, again, the negligence side of it, the insurance side of it, I'm not really, you know, an insurance person, but I think probably if that came up, I would maybe try and get somebody on our volunteer lawyer panel that does insurance defense. I'd imagine there might be a way, but I'm not just going to say I know, because I don't. I haven't really litigated, you know, a negligence claim against a landlord as a result of damage. It's just, I think that's one way to go. And, you know, trying informally to get a copy of their insurance policy, I agree that the landlord is probably going to be hesitant to do that. I'm not going to give it to you. Why am I to do that? Huh? Maybe not.
Yeah.
Maybe they would. But, you know, again, you know, we see this too in a more regular basis with fire. You know, a fire not caused by a tenant, damage to the property. I think we've got 2 ongoing cases like that now, you know, in our office, where they can't really live there and they're going to move out. You know, do they have any claim for their belongings that were damaged? They don't have renter's insurance. So I think we're, you know, consulting with pro bono, you know, insurance lawyers about that, because I think that can get, you know, interesting in terms of, you know, how to prove up those cases and who's liable and who's responsible. And I'm thinking cross claims and, you know, joinder of this person and that person, this insurance company, and, you know, so I don't know if that didn't really answer the question, but that's the best I can do.
Thank you.
Sure. Any other questions at this point? No? Okay. Got a few slides left. So what about, and this is a common issue if a storm hits, my brother, sister, aunt, mother, their house is totaled. They have nowhere to live. Where can they go? I get a call from my brother. My house is down. I have nowhere to go. I don't have enough money to move somewhere else. Can I move in with you? So can tenants have displaced families or friends stay with them? So Chapter 83, the landlord-tenant law, silent on this issue, doesn't really address it. Arguably, the terms of the written lease or whatever your oral agreement with the landlord, will apply. So we see this a lot in a different context, usually in landlord-tenant law. Anybody that's practiced landlord-tenant will say, what does the 7-day notice say, right? So there's two types of notices. 3-day notices, there's more than two, but the main two are 3-day notice, which is all about non-payment of rent. You haven't paid rent, you have 3 days to pay it. If you don't, then we're going to file an eviction. So there has to be some sort of a notice attached to any eviction that's filed. The other group of notices are called 7-day notices, right? And there's two types under the landlord-tenant law. One with opportunity to cure and one with no opportunity to cure. So going to the ones with no opportunity to cure, you threaten management. You waved a knife around, you did this, you did that. You were seen at 2 a.m. in the morning, inebriated and firing a gun in the air or threatening people. I mean, that's a clear no opportunity to cure situation. Or you're deliberately destroying property, those sort of things. The other type is an opportunity to cure. So the example I typically give is get rid of the trampoline, get rid of the dog, get rid of the car in the front yard that doesn't work. You obviously have a chance to cure that. Probably the same would be true, an opportunity to cure, if you have guests or occupants on the property that are in violation of the lease agreement. So what happens if you have a 2-bedroom apartment and all of a sudden 3 or 4 new people come in, your brother and their children, your sister and their children, and now they're living at your house, sleeping on the couch or whatever. What can happen there? Well, I guess it depends on what the landlord wants to do. The landlord can give a 7-day notice and say, these people can't live here, they're unauthorized occupants. So then again, the question would become, well, what's a guest and what's an occupant? People that start out as guests can turn into occupants if they're there long enough. So I think it's really a pretty serious question of fact as to what's going to happen in each situation. But if you don't comply with that notice and it's a valid notice, it can result in an eviction being filed, attaching the notice and saying you have 3 or 4 new people living here. Here's attached is the lease. The lease says that you need permission to add people. Here's the process. You didn't follow it. That would be something that would need to be argued. Can you argue, well, this is a special circumstance, there's a storm and this is obviously an emergency situation and we need this? Could argue that, which we're somewhat arguing in COVID cases, or bringing it up as a potential defense, that it's an equitable, and there's a duty of fair dealing and good faith of the landlord, and the eviction it would be inequitable to allow people to be removed in this situation. And I think that might give some discretion to a judge. But it's a tough issue. I guess communication with the landlord might be a good idea. Maybe it's not, but I think eventually if you've got a number of new people living in the property, the landlord's probably going to find out, and maybe it's a good practice to try and figure out maybe a time frame for the guests to be there while they're looking for a new place, maybe give them 30 days or, something along those lines. But this also can be an issue. And I think if I remember correctly, in the public housing or subsidized housing context, I think the HUD addressed it and they did allow very liberal rules for guests and occupants that normally wouldn't apply. So if you have a federally subsidized property, make sure you check on what the present status of that is, especially if there's an emergency, because that could be reasons. Obviously, in a federally subsidized context, if you have more people that are living there, there's an issue of, well, then what's their income, right? Because your income goes up and down with your rent. So that's one of the reasons that they're very interested in the public housing or subsidized housing context. Who's living there and what is their income? But again, memory being jogged here, I know that during states of emergency and storms, I think those regulations are not as strictly enforced. So check on that as well. So that is a difficult issue, but it's something that, and if it's an oral agreement, then there's not going to really be anything that says, a guest policy is not going to be in an oral agreement. So maybe there's a little more leeway there. But they still could probably give a 7-day notice saying, hey, we rent it to only you and not, 7 other people that are living there now. Prohibited practices. So I believe this is close to the end of our presentation. So what is a prohibitive practice? This is actually one of the better provisions of the landlord-tenant law in Florida. It prevents self-help evictions by a landlord, which involves directly or indirectly terminating utilities such as water, heat, light, so forth, refrigeration, changing the locks, removing doors, or removing personal property. So those are the kind of things that are defined as self-help eviction, meaning I don't want to go to the court. Why should I do that? Why should I hire a lawyer? Why should I pay a $200 filing fee? I'm just going to change the locks or shut the electricity off. This section of the landlord-tenant law prohibits that. It also provides for consequential damages or damages that are 3 times the monthly rent. So pretty substantial damage claim there. So we're seeing this as well with COVID, right? So frustrated landlords haven't been able to remove people because of moratoriums. I can't believe this. This guy hasn't, or gal hasn't paid in 5 months. Enough is enough. I can't evict them because of this moratorium. So I'm just going to take matters into my own hands, right? So that's coming up now. I think with a storm, though, it more likely would be, that the tenant has left the property, or the owner wants to get the property back to preserve it, and they don't want to waste their time going to court. They just want to get the property back and get in there and repair it. So very important, though, if electricity goes off because of the storm, that's not intentional conduct, right? It has to be done directly or indirectly by the landlord. So we argue indirectly, electric bill is in landlord's name, electric bill is not paid, electricity shut off by the local power company. That's an indirect termination by not paying the bill, even if they didn't directly go and like shut off the box or something like that, the circuit box.
Well,
sure.
What do you advise the client then? They come home one day, the door's gone or the lock's changed, the place is dark. What would you advise the client if they were having to go on their own? For some reason, they couldn't get an attorney.
Yeah, it does depend on the situation. So the lock situation, we always advise people call the police. Depending on your jurisdiction, you'd be surprised how many times the police come in and say to the landlord, hey, you can't do this, let them back in. Or we'd even advise clients sometimes to break in. I mean, you don't have your key, but you've got proof that you live there inside. That's a little more risky. Usually I think calling the police and having them come out, and if a tenant is thinks it's going to happen, like it's being threatened, we'll tell them, make sure when you leave your house, that you have on your person, a copy of your lease, copy of some mail for the property. So if you come back and there is a lock on the door, you can call the police and say, hey, look, I live here. Here's my proof, right? And sometimes, hopefully, the police will resolve it. We don't see too many doors taken off. A lot of times, I don't know what you would do in that situation. I guess you could technically go to, put up a piece of plywood and, basically make some sort of makeshift agreement so that, but then it's not really safe because you can't keep people from coming in. Most of the time, it's going to be a lockout or a shutting off of the electricity. Now, if the electricity is shut off, if somebody is truly pro se and they're, they don't know what to do, Sometimes they end up putting the power on in their own name, which, that's not really a great resolution to it. But you can do that and then have a claim later for the prohibited practice. If we get involved in it, typically we'll call the landlord first, say, hey, turn on the power by 5 o'clock tomorrow, or we'll go and file for injunctive relief down with the court. And large percentage of time, that usually resolves it. Sometimes, your tenant will say, well, they shut off the power, and then you get obviously the other side of the story. Maybe the electric bill was in the tenant's name and didn't know that. That's not a prohibited practice. If the tenant is supposed to pay for the electricity and doesn't pay it, that's obviously not the landlord's deal. But so for the unrepresented client, calling the police to resolve it sometimes does it, but more so within a lockout situation. Sometimes the police will say, well, go ahead, you can break in, and then potentially, I guess, change the lock so you get your own locksmith to come in. So tough situation. Is there any other question on that? I don't know if I answered that.
No, that's it.
All right.
Thanks.
So you have to be wary with a prohibited practice, and probably this is going to more obviously after a hurricane or a storm, the landlord may be more able to argue, hey, you abandoned the property. So if you abandon the property, then no evictions needed. Chapter 83 does not apply, and you can change the locks without going to court and getting an order from the judge. How is that defined under Chapter 83? If you're absent for the premises for 1/2 the time for periodic payments. So if you pay by the month and you're gone for 16 days and you're behind on your rent, then arguably you've abandoned the property. So it doesn't take too much to meet that definition, especially if it's a tough situation with a storm. So if your tenant is going to leave the property, we always say, make sure you give written notice to your landlord of where you're going to be after the storm. Your rent obligation continues unless, going back to the first part of the presentation, you've given a 7-day notice to withhold, you've given a 7-day notice to terminate, or you've exercised, partial or full casualty notice under 83.63. And the landlord cannot remove the tenant to allow friends or relatives to stay without a proper eviction. So I think this comes up a lot after a storm as well. Hey, you need to move out. Okay. This is my property, and my brother, sister, mother, aunt, cousin, their house, they need somewhere to live, and they're going to be living here. So you need to leave. So I think that's a unique situation with a storm as well. And obviously, you don't have to leave. They have to file some sort of an eviction case or have grounds for it, either a termination, violation of the lease or non-payment of rent before they can do that. But that may be another situation that may push a landlord to engage in prohibited practices. I don't really have a way to get you out. You're current on your rent. Presumably let's say there's no damage to the place you're living, but there's damage all around. Yeah, my friend over here, his house is total. He's going to move in now. Well, why? I mean, I'm paying my rent. I haven't violated the lease. Well, because I said so. Well, no, I'm not going anywhere. Okay, well, then I'm going to change the locks. So it all sort of can go like that, especially in that situation, because they don't really have a valid ground to evict. So that's, sometimes landlords evict when people are behind on rent just because they don't want to go through the hassle of filing an eviction. But in this particular case, there could be no ground to evict, and they just want to get their friends or relatives into the property. So that's a situation that may come up after a storm that's sort of unique to that. So I believe that is the end of my presentation. So I hope that was helpful. Any further questions?
There aren't any other questions. And thank you for presenting today. And thank you everyone for joining today. And come back next week, next Thursday at noon, where we're going to be talking about disaster public benefits with Cindy Huddleston and Ann Swirlick from the Florida Policy Institute and Daniel Rowinski from Legal Services of Greater Miami. Thanks, everyone, and I'll see you next Thursday. Bye now.